Hello and welcome to another tax update from Tax Essentials for Advisors. As ever, I'm your host Andy Rainford, sitting here rather sunburnt due to forgetting to buy any lotion before golfing last weekend. This week we have good news about business mileage rates, some new guidance about pensions and inheritance tax, and a case where a nurse was manipulated by a colleague. The approved mileage allowance payment rate for employees using their own car has increased with retrospective effect from 6th April 2026. The tax-free rate for the first 10,000 qualifying miles rises from 45 pence to 55 pence per mile. The 25 pence rate for mileage above 10,000 miles remains unchanged. It's also worth remembering that the national insurance exemption works slightly differently. For national insurance purposes, the full 55 pence rate applies to all qualifying mileage, even where the employee exceeds the 10,000 mile threshold. A new pilot advance assurance process for research and development. There is a new dedicated trust helpline and will run until May next year, available to use for queries related to income tax, aimed at SMEs for projects that fall into more complex or higher risk areas. For inheritance under the new approach, the existing eligible businesses can apply for advance assurance before submitting a claim. HMRC will review the company's activities and indicate whether relief is likely to be available. Where assurance is granted, HMRC says it will generally accept the first 3 years of claims, provided the projects and circumstances remain broadly the same. This could be particularly useful for businesses operating in areas where there has previously been uncertainty around eligibility. HMRC has published a new technical note explaining how inheritance tax will apply to unaccessed pension funds from April 2027. The guidance covers several practical areas, including how personal representatives identify themselves to pension scheme administrators and how the income tax position will operate. For advisors dealing with estate administration, this is likely to become an increasingly important area over the next year. The technical note is available using the link shown on screen. HMRC has issued a warning, confirming that it does not accept bills of exchange as payment for tax liabilities. The warning appears to relate to arrangements being promoted as a way of avoiding the umbrella company anti-avoidance legislation. HMRC says anyone who has entered into these arrangements should contact them as soon as possible. As always, advisors should remain cautious where schemes are marketed using unconventional payment mechanisms or claims that tax liabilities can somehow be discharged without actual payment of funds. In this first case, an NHS bank worker submitted self-assessment returns claiming significant deductions for home-to-work travel expenses over 4 tax years. The returns had been prepared by a colleague who had obtained access to the taxpayer's government gateway credentials and submitted the returns on her behalf. HMRC later opened an inquiry and concluded that the expenses were ordinary commuting costs and therefore not deductible. Discovery assessments, a closure notice and penalties for careless inaccuracies were issued. The tribunal agreed with HMRC that the expenses were not allowable. Although the taxpayer had been manipulated by her colleague, the tribunal said she had still acted carelessly by handing over her login credentials and by failing to question unexpectedly large repayments. However, the penalties were cancelled because the tribunal accepted that the taxpayer had effectively been a victim of coercion. So while the underlying tax liabilities remained due, the behavioural penalties did not apply. This case involved a large care home disposal project. Properties had been transferred intragroup into a newly incorporated subsidiary, with SDLT group relief claimed on the transfers. Before the eventual sale of that subsidiary to a third party, the parent company above the transferor companies entered members' voluntary liquidation. HMRC argued that this meant the purchaser had left the group within the 3-year clawback period, so the SDLT relief should be withdrawn. The tribunal disagreed. It accepted that the liquidation had been deliberately timed to preserve the relief, but said Parliament had drafted the exception broadly and the taxpayer had accepted the genuine legal and economic consequences of liquidation. The case is another reminder that tax planning will not necessarily fail simply because steps are taken with tax outcomes in mind, provided the statutory conditions are genuinely satisfied. And that's it for this update. Thanks for watching, and I'll catch you again in a few weeks' time.
Thanks for that, Andy. Hope you've at least remembered to put some after sun on. Don't forget we have another free CPD accredited webinar coming up next month for you. Ed Thompson will be joining Andy and Rachel to talk about VAT planning with the option to tax. The link to register is showing here for you. Bye for now.